5-0.
Doc, these are very sad times for our democracy and for the good people of this country. You know, since this matter broke, specifically since the Supreme Court made a strange order for stay of execution of the ruling or communication from the Speaker declaring 4 seats vacant, I have deliberately decided not to comment on this matter. And so I have not discussed the matter on any platform. I have not commented on it. I've declined all calls from media organizations to comment on this matter. Because, Doc, as a Ghanaian and as a lawyer, honestly speaking, I am fatigued about the injustice that is persistently being done by the apex court of the land, the Supreme Court. I'm fatigued. I'm tired. It is frustrating. It is draining. It is depressing to read the kind of decisions that are coming out of the Supreme Court of Ghana. Sometimes when you see some of the things they say, you become nauseous as a lawyer. And you ask yourself, is this the Supreme Court of Ghana? Is the Supreme Court interested in justice? Are they interested in upholding the rule of law? So it's become so draining, and so I have decided to just focus on the campaign. But you see, though, what happened in the Supreme Court yesterday, and some of the pronouncements, the court, speaking through the Chief Justice who presided, said cannot be allowed to just pass like that. And so I'm breaking my own, determination or my own bond not to comment on matters emanating from the Supreme Court, to comment on this matter. Because, look, I have never seen the kind of injustice we saw yesterday, that the Supreme Court can actually lie. Okay? In fact, let me single out the Chief Justice. Let me place emphasis on the Chief Justice. That the Chief Justice who has authored a document and happened to be the one presiding could actually lie about a document she herself authored.
What lie did she tell?
Look, I want to demonstrate to those who have been, disputing some of the things we in the NDC have said about the bias of Chief Justice Getru Tokono and the Supreme Court. I want to demonstrate this with simple facts that will leave no objective mind in doubt that what Getru Tokono CJ is doing is not law. It's the desecration of justice and the rule of law. Simplicity. Look, yesterday on the issue of service, whether or not at the time Speaker Bagbin delivered that communication to Parliament declaring the said 4 parliamentary seats vacant, he had been served with a writ from the Supreme Court by the plaintiff, Afenyo Maken. Was a very important issue for determination in the matter or in the application that came before the Supreme Court yesterday, and in fact in their own ruling. And the reason why the issue of service is important is that the Supreme Court, one of the primary responsibilities of the Supreme Court is to enforce and interpret the Constitution. But the emphasis here is on the enforcement of the Constitution. The Constitution as a whole, not just one article. And Article 117, that is 117 of the Constitution, says that no process from any court includes the Supreme Court, or any place out of Parliament, can be served on or executed against the Speaker, an MP, or the Clerk of Parliament when they are on their way to Parliament, they are attending at Parliament, or they are on their way from Parliament. That is the Constitution. You can't serve any process on any court on them on their way to Parliament, when they are in attendance at Parliament, or when they are leaving Parliament. And the Supreme Court is supposed to enforce this. So if you serve any process on the Speaker of Parliament when he is attending Parliament, or when he's on his way to Parliament or from Parliament, that service is unconstitutional. It's not proper service. Now, in recent time, the Speaker has been concerned about officers of the court, from the registry of the court, bailiffs, serving processes on MPs, clerks, and the Speaker against this constitutional provision, which makes them liable for contempt of Parliament. But because the Speaker believes in a harmonious coexistence of all the three arms of government, and doesn't want to be seen as citing bailiffs of the courts for contempt, for breaching these provisions and all that, he wrote to the Speaker, the Chief Justice, drawing her attention to this and said, look, the way and manner bailiffs are serving processes on the Speaker, MPs and all that, it's against the Constitution. It's not right. You are the head of the judiciary. You exercise that administrative authority over the entire judiciary, which includes the registries, the bailiffs and all that. So let's resolve this matter. Then this current CJ, the previous CJ had done something in that area, but let me talk about the current CJ, get to talk on. On the 12th of July 2024, wrote the circular to Speaker Boye. Before I tell you what is in this circular, I have given a short video, just 1 minute 30 seconds or something, 27 seconds, to Annie on what Madam Justice Gertrude Tokono said for and on behalf of the Supreme Court on this issue of the circular and what is in her own circular and the meaning of what is in her own circular. So, Doc, if Annie can just play that video for starters.
Let's watch it.
If Annie can just play that video for starters.
Let's watch it.
B. Honorable
grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 18 of the High Court Civil Procedure Rules 2004 CI 47, that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Code, that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. and the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day.
Good.
3, 2, 1. So what about this?
So the Chief Justice is interpreting her own circular. She says that the interpretation put on the circular by the Chief Justice is unfortunate.
By the Speaker.
By the Speaker is unfortunate. And that if you check the first column of that circular, the Speaker is supposed to be served personally only on Mondays. But the legal department of the parliamentary service can be served on any other day.
Yes.
So, Doc, I brought 3 copies of the circular. One for Boye, one for you. This is the circular. No, give it to Doc. No, give it to him. Then one for me. And Annie has a soft copy of the circular. So, Annie, can you kindly put the circular on the screen? Let everybody see it. Chief Justice says, per the circular, the Speaker can only be served personally only on Mondays. She says the first column. But when it comes to the legal department, on any other day of the week. Look, I need not read the preceding paragraphs for the sake of time. But let me read it quickly. This is what the document says. To all registrars of the court and bailiff, circular. The date is 12 July 2024. Enforcement of Article 112 and 118 of the Constitution. Immunity from service of process and arrest. It says enforcement of Article 117 and 118. The Honorable Lady Chief Justice's attention has been drawn by the Right Honorable Speaker of Parliament to potential breaches by actions of some officers and some persons acting on behalf of the Judicial Service of Article 117 and 118 of the 1992 Constitution. Articles 117 and 118 of the Constitution provides that, she quotes that. Then she continues, these provisions ensure that the office holders listed above may not be served any process of court or compelled to appear as a witness in court unless Parliament is not in session or the Speaker so satisfied that the office holder in question is not on his way to, attending, or returning from any proceedings of Parliament. Attention has also been drawn to a circular issued on 22nd February 2021. The Honorable Lady Chief Justice is informed that there have been attempts to serve court processes of members of Parliament. She continues, I need not read all. In view of the foregoing, Annie, can we have the page 2 on the screen? In view of the foregoing, the Honorable Chief Justice has therefore directed that in serving processes to the above mentioned officials, the following should be adhered to henceforth. Now, the woman says if you check the first column of this circular, the Speaker can only be served personally only on Mondays, and the legal department served on any other week. As a Yanyako school, we know what a column is. Check the first column. What is a column? The column is the vertical part. So you see, in their haste to dismiss the application, they even confuse column with row. Obviously, what he was talking about was the first row, the horizontal. Look, Alai, look at the first row. Number 1, personality or institution to be served, Right Honorable Speaker of Parliament. How service should be effected? Look, this is it. All court processes should be served on the legal department of the parliamentary service. Acceptable times of service, Mondays during working hours. Mondays during working hours. Where in this column, row or circular, is it written that for the Speaker of Parliament, he can be served personally on only Mondays? But for the legal department, on any other day of the week, where is it written? Madam Gitri Tokon. Where is it written?
So when you look at 2 and 3,
yes,
the one to the clerk to parliament,
yes,
and members of parliament,
yes,
when you look at those 2,
yes,
you will see that where the intent,
yes,
of the circular,
yes,
was to indicate that they could be served on days other than Monday.
it is stated.
It is stated.
Because you see, when you are suing parliament,
so first of all, they state Tuesday to Friday.
Exactly.
And they state the time.
Exactly.
So
7 a.m. to 8 a.m.
So that if the intent was that you could serve the Right Honorable Speaker personally.
And it is not even there. There is no part of this this column or whatever
on Mondays.
And serve legal department on any other day.
It will be stated.
And
then if the intent was that you can serve the Speaker on Monday, but you can serve the Speaker through
the legal department on any other day,
on Tuesday to Friday, just like it's in 2 and 3.
It would have been stated. Because when you are suing parliament, or if you are serving a process on parliament, you serve the clerk. And when you are serving the clerk, the Chief Justice says you can do it on Mondays or any other day of the week. That is other weekdays, Tuesday to Friday,
even with
7 a.m. to 8 a.m.
They give you a time.
7 a.m. to 8 a.m. And then for members of parliament, on Mondays, because MPs don't work on Mondays, usually, they don't work on Mondays. And then on Tuesdays to Fridays, by 7 to 8, Parliament is not sitting. So that agreement, because the Speaker and the MPs could have even argued that by 7 we would have been on our way to Parliament. So it would have been impossible to serve them. But they have all come to this.
So you see that even
compromise position.
You see that even the Speaker, when Parliament on recess is not even applicable to him.
No.
Yeah.
When Parliament is on recess, you
it's
can
not
serve
even applicable.
You can only serve the Chief Justice in this circular never made any provision for serving anything personally on the Speaker.
Yes.
This document says the only way you serve the Speaker, and we can see the first row. The only way you can serve the Speaker is to serve the legal department of the parliamentary service. And you can do that only on Mondays.
Yes. So there's nothing like a personal service on him.
Why will a woman who is Chief Justice author this document herself? I'm sure that when they retired into chambers to write their ruling.
Okay. Don't insinuate, just make a point.
Yes, I'm sure that, I'm being fair to her. She would have even taken another look at the circular to refresh her memory.
But there's a point she made in the course of the thing by emphasizing the. The impression I got was that she was looking at things from a hierarchical order. That look, you can't escalate a circular when people are talking about the Constitution.
She's right in that.
Yes.
She's right in that.
Yes.
But what gave birth to the circular? The highest law of the land. Article 117 and 118. That is why the title of the circular is Enforcement of Articles 117 and 118. The Constitution, which is the supreme law of the land, has provided for how the Speaker should be served. And when he's attending Parliament, or on his way to Parliament or from Parliament, you can't serve him. And you has given a direction to bailiffs and officers of the court on how they can serve processes on the Speaker without violating 117. You understand? So this is not an issue of somebody, the Speaker, elevating a circular above legality. Because the Speaker is relying on Article 117, which is a constitutional provision. This circular is only an administrative action by the Chief Justice to guide the judicial service to prevent a situation where they breach 117 and 118 of the Constitution. So you get my point. So nobody is elevating a circular above a constitutional statutory provision or the principle of legality. That's number one. Number two, let's even say that is what the speaker was doing. At least in interpreting the document, give the correct interpretation. This is a document that is coming from the Chief Justice. This is the Judicial Secretary signing on behalf of the Chief Justice. In view of the foregoing, the Honorable Lady Chief Justice has therefore directed, and the Chief Justice is in copy. Why would the Chief Justice lie this way? Is she Chief Justice or Chief of Injustice? Why?
Okay.
This is a sacrilege. This is disgraceful. Look, let's put this aside.
Right.
On the issue of jurisdiction, Master, clear provisions of the Constitution. You don't have to be a lawyer to understand. And you can put a screenshot of Article 99 on the Article 99 of the Constitution on the screen. Clear in all matters.
In your opinion,
of course, everything I'm saying here is in my opinion.
At least five
but at least
5 justices of the Supreme Court do not think so.
But at least Justice Atuguba agrees with me.
No, I'm saying that 5
they disagree with me. I'm sure that,
and
I'm saying Justice Atuguba agrees with me. MPP lawyer.
That's 5-1.
MPP lawyer Kwame Okufu. One vote can be bigger than 5.
That's 5-1.
Because when it comes to constitutional law, if you read decisions of Justice Atuguba, you will know that he really understands constitutional law. He's an institution in that area. And I'm sure that even if we call all the Supreme Court judges to cast a vote on the meaning of Article 91 in the issue of jurisdiction relative to this matter, that 5 will be in the minority. But 99 is clear. When it comes to vacation, whether or not an MP has vacated his seat, it is a matter within the jurisdiction of the High Court. The Chief Justice and the Supreme Court don't disprove that.
In reading the ruling,
yeah,
the CJ went through all that.
I will show you that everything disingenuous. I'll play another tape. You see, she says, what is her argument? She says that Article 2 and Article 130, first of all, Article 2 gives any citizen, any person, the right to go to the Supreme Court. When there is an act of omission.
Sammy, here, you seek to tell us your understanding of those constitutional provisions. And you seek to make the point that your understanding of that part of the Constitution is superior to the view of the 5 justices.
Exactly. Just like, have you heard the case of Ray Akoto?
Yes.
It was a unanimous decision.
Yes.
But why is it that when you go to law school and you are learning constitutional law, is the first case they teach you?
Yes.
Judges and lawyers from that time till now have all condemned that unanimous decision.
Yes.
Because it was clearly a bad decision.
Yes.
You understand? So the fact that
but there are many
the fact that the decision was a unanimous decision
is useless.
Exactly. Yeah. Yes, and majority. So for me, it's about the strength of your argument. You understand? Whose argument makes sense?
But this is not where to contest it.
But where else can you contest it?
You don't get what I'm saying.
Yes.
I'm saying that the justices of the Supreme Court have unanimously expressed their opinion of
and their opinion is law. But we are entitled to disagree with them and show that that opinion is baseless, it is bogus, it is per incurium. You understand? We have every right to critique it.
Yes.
And that is why I'm not insulting anybody, I'm critiquing it.
Okay.
And I'm saying that the Supreme Court itself, in several decided cases, have said that you cannot disguise a matter which has to do with a challenge of the validity of the election of an MP or the vacation of the seat of an MP in a form of a constitutional issue. Bring the matter under Article 2 and Article 130 and expect the Supreme Court to accept jurisdiction. The Supreme Court will always decline.
So what I heard,
I will give you practical examples.
I heard the CJ say yesterday, and I hope that I will be stating it right. But because I watched, what I heard her say was that the suit that was filed a day before and which in the opinion of the Supreme Court was
properly served
on
which
the
I've
speaker.
demonstrated is a lie.
No, but I'm saying that in their ruling, they said that as far as they were concerned, they were convinced that it was proper service.
But it was a lie.
So what they're saying was that that particular action was to invoke the jurisdiction of the Supreme Court to interpret the Constitution.
Yes.
So as far as we're concerned, the Speaker was aware of a writ before the Supreme Court for the interpretation of a Constitution.
Yeah.
And therefore, the issue in hand had to do with an interpretation of a Constitution, not the High Court's role of dealing with the vacancy of a seat.
No, you see, what they are saying is simple. They are saying that even though the Constitution gives jurisdiction to the High Court to determine the validity of the election of MPs and whether or not an MP has vacated their seats, the Supreme Court is saying that when that matter about the validity of the election of the MP or whether or not the MP has vacated his seat has to do with the correct interpretation of a constitutional provision, they have jurisdiction under Article 2 and 130. That's what they're saying.
No.
What they are saying, let me even reframe it to make it better. Hold on, you understand me?
What I heard them say was that the suit brought by Honorable Afenyo Makin was about whether the declaration of vacancy has to do with the 8th Parliament or the 9th Parliament.
Yes, so they are saying that it involves a constitutional issue.
Yeah, they were being called upon to interpret whether it takes effect from the 8th or the 9th Parliament. And that has nothing to do with the jurisdiction of the High Court.
Yes. Yeah. And she even went on to say that where somebody alleges, in fact, the real ratio of that decision is that according to the Supreme Court, speaking through
substance,
the reasoning, okay,
right.
When the Supreme Court speaking to the Chief Justice, who was presiding, said that where the dispute about the vacation of seat or the validity of the election of that MP is a matter of fact, then it is within the bosom of the High Court.
True.
But if it is a matter of whether or not the election of that person or the declaration of that vacancy is in line with the Constitution or in violation of the Constitution, then it is an interpretation matter that the Supreme Court has jurisdiction over.
Right.
That is the reasoning of the decision.
Yes.
And I'm saying that reasoning
is
per incurium, or it flies in the face of several decisions of the Supreme Court.
Okay.
Let me give you a typical example. Have you heard of the case of Yeboah versus J.H. Mensah?
Yes.
In the case of, in the 1996 election, J.H. Mensah was elected as the MP for Sunyani East. And a gentleman called Yeboah, who lives in this electoral area, went to the Supreme Court. Okay? He didn't go to the High Court. 21 days elapsed, and after that, he went to the Supreme Court and said that he was coming under Article 2 and Article 130 because the election of J.H. Mensah was unconstitutional. Why? Because of Article 94 of the Constitution, which says that to qualify to be elected as MP, you must be a resident of the constituency, or you should have been a resident for at least 5 years out of the 10 years immediately preceding that election. So his argument was that J.H. Mensah was living at Odomase, and Odomase is in Sunyani West, but he had been elected as MP for Sunyani East, and that J.H. Mensah had been in exile and had only come to reside in the area for 2 years, and so his election was in violation of Article 94 in the sense that he didn't meet the criterion of residency. Doc, you get the point? So it was a case about the election of J.H. Mensah being in violation of the Constitution. It required interpretation, It required interpretation. But the Supreme Court in that case said, you cannot dress an election petition case, which per Article 99 has been given to the High Court, in the garb of a constitutional issue, come under Article 2 and Article 130 and expect the Supreme Court to accept jurisdiction. So a preliminary objection raised by J.H. Mensah that the Supreme Court had no jurisdiction to entertain the matter, and that per Article 99, the matter ought to have gone to the High Court. The Supreme Court upheld it and dismissed the matter. That also involved interpretation, because that issue of residence was something that the Supreme Court had to interpret. Why didn't the Supreme Court accept jurisdiction? I give you another example, Gyamfi Kwesi. Why should I even use Gyamfi Kwesi? Let me use Gyamfi Kwesi. The Gyamfi Kwesi, what was it about? Article 94, 1A. After he was elected, then PP went to the High Court in Cape Coast and said, at the time of his election, he owed allegiance to a country other than Ghana, because he was a dual citizen. He was a citizen of Canada. So by owing allegiance to Canada, he was unqualified. Then DC raised an interpretation issue that owing allegiance to a country is not the same as having dual citizenship. You know, so didn't we discuss the matter here? The matter went to the Supreme Court. The Supreme Court said the High Court and the Court of Appeal that determined the issues were well within their rights, because per Article 99, they had the jurisdiction to determine it. Read Collins Dauda. The same thing on Collins Dauda. The Supreme Court was clear that when it comes to Article 99, if you're challenging the validity of the election of an MP, or you're challenging whether or not an MP has vacated the seat, the place to go is the High Court. What is the substance of Afenyo Makin's writ before the Supreme Court? That it is wrong for anybody to interpret Article 97 1G and H, and on the basis of that, he didn't even make reference to H, but he restricted it to G, and on the basis of that say that the MPs having filed nominations to contest to be part of the 9th Parliament have vacated their seats in the 8th Parliament. So what is he challenging? He's challenging whether or not the MPs have vacated their seats. And the Constitution says when it comes to whether or not an MP has vacated his or her seat, it is for the High Court. So you go to the High Court, and that issue of the disputed interpretation or meaning of that provision then comes up. Afenyo says the meaning being put on it by the Speaker is wrong. The Speaker says I'm right. Then per Article 132, the High Court is bound to refer the matter to the Supreme Court. That is what's happened in the case of Zaneto. The only case the Supreme Court cited yesterday to ground their jurisdiction was the Zaneto case. But that is the case which exposes how flawed their decision is.